The Constitution will not be saved in Washington.
I belong to the Church of Jesus Christ of Latter-day Saints.
Travis Wayne Goodsell, while searching to find the answer of what will I do when all federal judges recuse themselves, leaving no judge left to preside over a case, I found that there's an actual law on the federal books. If I'd only known before I did my amended complaint, including Judge Waddup's, who was in violation of this law, rather than stating it. So the law code is USC 28, Part 1, Organization of Courts, Chapter 21, General Provisions, Section 455. It's titled Disqualification of Justice, Judge, or Magistrate Judge. I had called for the denial of Judge Oberg based on this information without knowing this law, and Waddup still refused. So, here we go. Any justice, judge, or magistrate judge of the United States shall, not could consider, shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. Being Mormon is reasonable to question. He shall also disqualify himself in the following circumstances: where he has a personal bias or prejudice concerning a party, or personal knowledge of disputed evidentiary facts concerning the proceeding. Isn't that interesting? This has been the defense counsel's constant dismissal claim, is that it's over disputed evidentiary facts. They claim it's not sufficient to justify request for relief, where I say, no, I'm following the federal civil pro se litigant guide, and I'm going to stick to that, because otherwise you guys are claiming that the pro se litigant guide is incorrect. So who am I going to believe? Exactly. But also in this, in my brief to Judge Kimball, who should be recused by now, whom I'm expecting to see his recusal after midnight tonight, I pointed out that he knows me, I know him, in regards to a previous matter against the church back in 2005, 2006. and thus he needs to recuse because of his personal connection to me and the church going back then, along with his personal bias and family bias and religious bias. So yeah, this is interesting. I am expecting to do another brief tomorrow. Maybe it should be an emotion. I don't know who's going to hear it. Because if no judge can hear my case, what do I do? Maybe I should send it to the chief judge, but I don't know. But maybe do a motion for an automatic win. I'd have to see if I can find something like that. And I guess it already has been shown to me, as I already have those laws. I just have to find it, because, well, we'll see. Yeah, every judge is compromised by the church, either as Mormon or Utah, knowing their dependence upon the church. However, I do not know the chief judge and senior judge Tina Campbell. I can't establish them as if they're Mormon or not, but I can't identify if they're compromised as well. I have to do some research into the cases they've tried, but maybe I should go to the chief judge. We'll see. But I think after strike 3 for recusal, I should have cause to request an automatic win based on this, that I cannot receive a fair hearing in the state of Utah because of the stacked court, the stacked judicial court, stacked bench, and see if the chief judge will grant the victory. But again, I still have to see if I can find some other stuff on this. I thought this was just the code for judges. I didn't realize this was an actual law. Let's see. Oh, yeah, this also, number 2. Where in private practice he served as a lawyer in the matter in controversy, or a lawyer with whom he previously practiced law served during such association as a lawyer concerning the matter, or the judge or such lawyer has been a material witness concerning it. All Mormons are material witnesses. Loyalty oaths in the temple to the church rather than the United States government. Wow, this just gets more intense as we go on here. Let's see. 3 is serving in governmental employment or in such capacity participated as counsel, advisor, or material witness concerning the proceeding. I'm not quite sure if that applies here. 4, he knows that he, individually or as a fiduciary, or his spouse or minor child residing in his household, has a financial interest in the subject matter in controversy or in a party to the proceeding. All Mormons have a financial interest in the church. They have to pay tithing in order to go to the temple. they have a financial interest, or any other interest that could substantially affect by the outcome of the proceeding. Yeah. He or his spouse or a person within the third degree of relationship to either of them or the spouse of such a person is a party to the proceeding, or an officer, director, or trustee of a party. Yeah. If these two judges are not Mormon, but they married a Mormon, if they have donated to the church because they think that they're doing charitable causes, we'll see, is acting as a lawyer in the proceeding. Okay, no, this is for judges who have to, right? Justice, judge, or magistrate judge, acting as a lawyer? Huh. Okay. Not quite sure of a scenario where that would apply. I guess I need to go back and watch Law and Order to see if they do something on that. Is known by the judge. Wait a minute. Oh, okay. So it's a third degree relationship is acting as a lawyer. So no nepotism. Got it. Okay. Yeah, that would be interesting if Taylor or Sven are related to any of the judges in a third degree situation. I have no idea. Is known by the judge to have an interest that could be substantially affected by the outcome of the proceeding. Yes, they're Mormon. Is to the judge's knowledge likely to be a material witness. No, I'm still thinking in terms of the judge here. It's his spouse. Yeah, well, spouses have an interest also to the outcome. Spouses and family members likely to be material witnesses. Yeah, I could easily, if we went to a trial, say, Your Honor, I'd like to call your wife to the stand. As a Mormon, do you raise your right arm to the square, thumb extended, and give loyalty oaths to the defendant? Yes. Yes, I do. C. A judge should inform himself about his personal and fiduciary financial interests and make a reasonable effort to inform himself about the personal financial interests of his spouse and minor children residing in his household. Uh-oh. So, wow. For the purposes of this section, the following words or phrases shall have the meaning indicated. Proceeding indicates pretrial, trial, appellate review, or other stages of litigation. So I should probably start using these words and terminologies. The degree of relationship is calculated according to the civil law system. Fiduciary includes such relationships as executor, administrator, trustee, and guardian. Okay, so maybe fiduciary doesn't qualify, but financial interest would. means ownership of a legal or, well, maybe not, or equitable interest, however small, or a relationship as director, advisor, or other active participant, there we go, in the affairs of a party, except that ownership in a mutual or common investment fund that holds securities is not a financial interest in such securities unless judge participates in the management of the fund. An office in an educational, religious, charitable, fraternal, or civic organization is not a financial interest in securities held by the organization. And so they're saying that the office is not considered a financial interest. So Kimball's teaching position at BYU can't be considered. The propriety interest of a policyholder in a mutual insurance company ownership of government securities is a financial interest, is the issuer only if the outcome of the proceeding could substantially affect the value of the securities. Okay, so financial interest, they're trying to claim that an office in a religious organization now the presiding bishopric said that the members are the I can't remember the word, it's something like the wealth of the church. So I'm not sure how that applies, because the church is different than all other churches. We are required to pay in order to participate in the rituals, whereas other churches you don't have to pay. Catholics request a charitable donation. Rather than a forced payment. And then they also have that sale of indulgences thing. But it's not forced per se. It can be somewhat gang-tied, that if you don't pay enough, then your service drops. But interesting. Okay. See, the thing is that the previous case dealt with how they're a criminal organization, and that got dismissed because they're using religion as a front for criminal activity. But it does say other interest that could substantially affect, so we can stick with that at least. Any other interest in number 4, where the financial interest is. So still applies, just I have to be careful not to focus on the ones that the law doesn't quite recognize the church as violating yet. No justice, judge, or magistrate judge shall accept from the parties to the proceeding a waiver of any ground for disqualification enumerated in subsection B. Okay. Is a denied motion to recuse a waiver? Let me check the definition of waiver. Oops. Still have it on capitals, caps. Waiving. No, I want. Restrain from insisting on or using a claim. That's what they're doing, is they say, I don't have a claim upon which relief can be granted. So yes, refrain from insisting on a claim or using a claim. So denying my motion does apply. So waiving my, wow, yeah, so that applies. E. No judge, justice, judge, or magistrate judge shall dismiss a plaintiff's a motion to recuse based on B. Yeah, bias or prejudice. So, yep, Oberg was illegal indeed on that, and Judge Waddups as well, and Judge Jenkins, when he dismissed my waiver, or when he accepted because yeah, it involved Judge Waddups in the first count, or in the first complaint, and then Jenkins was added in the second amended complaint. Where the ground for disqualification arises only under subsection A, waiver may be accepted, but that's not the case. It is under B as well. So, and then F, notwithstanding the preceding provisions of this section, if any justice, judge, magistrate judge, bankruptcy judge, to whom a matter has been assigned would be disqualified after substantial judicial time has been devoted to the matter because of the appearance or discovery after the matter was assigned to him or her that he or she individually or as a fiduciary or his or her spouse has a financial interest, affecting the outcome, disqualified not to a judge, as the case may be, vest themselves or interest. If any judge or justice assigned after substantial judicial time has been devoted to the matter because of the appearance or discovery after the matter was assigned to him or her that he or she individually disqualified is not required if the justice, judge, or magistrate judge provides the grounds for divests himself or herself of the interest that provides the grounds for the disqualification. All right. So yeah, if they say, I have taken my name off the membership of the church, that would qualify. And so yes, Judge Jenkins did not submit such thing. Instead, he recused. So yeah, if the Mormon judges want to take away their membership in the church, then they can proceed to judge the church. I'm sure the church would be more than happy to have an ex-Mormon being their judge. So we'll see tomorrow when I wake up and check if Judge Kimball has indeed recused himself. And if he has, I may submit a motion to the chief judge. We'll try that. Because let's see if I can find something on the chief judge. Role of federal chief judge. Following are duties of a chief judge. Ballotpedia.org. Ensuring that laws, regulations, and court policies are followed, and they're not. Monitoring court caseloads, developing and implementing short and long-term court plans, direct supervising the clerk of the court, overseeing local rulemaking, resolving informal disputes, reviewing court budget and court spending, overseeing space acquisition, ensuring court security, appointing and serving on court committees, filing reports and plans, serving as a liaison with outside groups. So I guess ensuring that laws, regulations, and court policies are followed is what I would use to appeal to him. U.S. District Courts. Supervise chief probation and pretrial service officers, monitor magistrate judges, oversee the use of jurors, maintain effective relationships. Chief judge is also given exclusive authority to appoint. Have to be under 64 years old. Okay. All right. So, yeah, I can go to him and say, hey, this law is being violated in my two cases here. The first one has already been dismissed because Judge Waddup refused to recuse himself, as Judge Oberg dismissed that recusal. And so, yeah, we may default as a result, as they are purposely preventing me from submitting a complaint. Yeah, where one party has failed to perform, let's see, a default, let's go to, means a party has not done what is required of them in the time allowed. That's according to Utah courts. No, we don't want Utah courts, we want federal. So let's go to Law Cornell. Civil procedure, legal process. A default judgment is a ruling granted by a court or judge. Default judgments arise in circumstances whereby one party to a suit has failed to perform a court-ordered action. Following the law, not following the law, I think qualifies, and subsequent that failure has not only prevented the issue from being presented before the court, but also results in the court settling the legal dispute in favor of the compliant party. For example, when a defendant is summoned to appear before the court in a case brought by a plaintiff, but fails to respond to the court's legal order, the judge can rule for default judgment, and thereby decide the case in the plaintiff's favor. And that's the one example. But this would be for not following the law. It would go in my favor. The defendant, though not present before the court, is obligated to abide by the court's ruling. And thus the judges being involved in this on behalf of the defendant automatically is a default. So from the stronger. I got Latin terms here. We have a fortiori, from the stronger. If a particular fact is true, then one can infer that a priori, a particular idea is taken as given. Ab initio, from the beginning. Oh, mercy. So, yeah, well, my goodness. Let's check out the legal process. It's the same thing. Alright. So those are just definitions and word usages to use. But yeah, default judgment. That's what I'll have to submit it by. If Judge Kimball does not recuse, maybe I should still do it. And go from there. So maybe we can have this. No! Word pisses me off. Alrighty. Okay. So interesting. Okay, I'm looking for a law on default judgments. Not seeing one. It's just referred to in the laws that I've seen, which is what I was looking for. Alrighty. So, stay tuned.